Assalamualaikum warahmatullahi wabarakatuh, the honorable of the lecture and all of the audience. Thank you for your attention and I hope your week going well so far. My name is Anya Insazara Ali Rosadi from Civic International class in Hasanuddin University. Today, I'm going to talk about constitution system in Indonesia. Before we start, let me tell the purpose of this material. Well, students as graduate and professional candidate are expected to first have personal and social commitment to the realization of the values and norms contained in the Constitution in Indonesia. Second, able to analyze the value and norms contained in the Constitution in Indonesia and the constitutionality of the provision under Constitution in the context of the life of the Indonesian nation. Third, able to create mapping of consistency and coherence between value and norms contained in the Constitution in Indonesia and the constitutionality of the provision under the Constitution in context of state Indonesian nationality. The Constitution of Indonesia. The 1945 State Constitution of the Republic of Indonesia or Undang-Undang Dasar Negara Republik Indonesia or we usually called UUD is the basis for all laws of Indonesia. The Constitution was written in June, July, and August 1945 when Indonesia was emerging from Japanese control at the end of World War II. It was abrogated by the Federal Constitution of 1949 and the Provisional Constitution of 1950 but restored on 5 July 1959. The 1945 Constitution then set forth the Pancasila, the five nationalist principles devised by Sukarno as the embodiment of basic principle of an independent Indonesian state. It provides for of limited separation of executive, legislative, and judicial power. The governmental system has been described as presidential with parliamentary characteristic. Following major upheavals in 1998 and the resignation of President Suharto, several political reforms were set in motion via amendment to the Constitution, which result in change to all branches of government as well as additional human rights provision. Next slide is constitutional concept. C.F. Strong, who adheres to modernism, firmly equates the Constitution with the UUD, a collection of principles regarding government power, the right to be governed, and the relationship between the two. Document that can be changed according to the times. In a broad sense, Constitution is the entirety of the basic provision or basic law, whether written or unwritten or a mixture of both. Meanwhile, in narrow sense, Constitution means a basic character or basic law, which is a complete document regarding the basic regulation of the state. Second slide is constitutional function. Constitution function, first, limiting or controlling the power of the ruler so that in exercising his power it is not arbitrary to the people. Second, provide a legal framework for the change in society that it aspires to. Third, it is used as the foundation for state administration according to a certain constitutional system which is upheld by all its citizens. Last, guaranteeing the basic rights of citizens. Third, essence and urgency of the life of the Indonesian nation. The 1945 Constitution of the Republic of Indonesia, as the Constitution, has a position as the supreme law and the basic of law of the state. As the country's supreme law, the 1945 Constitution of the Republic of Indonesia occupies the highest position in the level of legal norms in Indonesia. Meanwhile, as a basic law, the 1945 Constitution of the Republic of Indonesia is a source of law for the formation of law and regulation under it. Lord Acton said, "Power tends to corrupt and absolute power will corrupt absolutely." And this is the pyramid of constitution in Indonesia. Regulation and laws are written regulation, containing legal norms which is binding in general form or stipulated by state institution or authorized official through the procedure stipulated in the legislation, placing Pancasila as the basis and ideology of the state as well as the basis for the philosophy of state, so that any material contained in the values contained in Pancasila. Fifth, historical, sociological, political, and constitutional resources in life of the Indonesia nation. First, historical trouble. The view of Thomas Hobbes, the adage Homo homini lupus, or man is wolf to his fellow man. Second, then came the view of bellum omnium contra omnes, or war of all versus all. Third, agreement between human beings factum unions. Fourth, the people handed over their power to the rules to maintain the people's agreement factum subjections. Fifth, political obligation called social contract, which implied the transfer of sovereignty to primus inter pares, who then ruled absolutely or absolute. Sixth, absolute monarchy or absolute kingdom, with the concept of divine right, which states that the rules on earth is God's choice so that he has unmatched authority. Last is the view has it to emergency of tyrant kings. Last, post-amendment to the 1945 Constitution. This is the structure of the Constitution of Indonesia. State power after amendment. First, constitutive by MPR. Second, executive by President. Third, legislative by DPR. Fourth, judiciary by MA, MK, and judiciary. And last is monetary by Bank Indonesia. Well, I think that's all my presentation about Constitution in Indonesia. Thank you for your attention. If there is a mistake in my presentation, I want to say sorry. But may all those I have shared be beneficial for all of us. And wassalamualaikum warahmatullahi wabarakatuh.